Hi! Continuing our discussion on the law of state responsibility, I now want to turn our attention to the consequences of international legal responsibility, and specifically to the topic of countermeasures on the one hand, I briefly addressed this already in the previous clip, and on the other hand to the important question of reparations. It might be redundant to highlight this, but both countermeasures and reparations only come about when there actually has been a breach of international law and one that is attributable to a particular state. This is why we talk about the consequences of international responsibility. Without such an attributable wrongful act, none of the two aspects even arise. What then specifically are countermeasures? Well, there's an entire chapter in the RCVA that is dedicated to this, namely chapter 2 of part 3, which in Article 49 in the second paragraph also includes a definition, stating that a countermeasure is in fact a non-performance for the time being of an international obligation of the state taking the measures towards the responsible state. Two aspects of immediate relevance here. The first is that a countermeasure, in former times also known as a reprisal, is in fact itself an illegal act, but one that is justified under international law and is therefore also to be found in Article 22 of the RCVA in the chapter on the circumstances precluding wrongfulness. It is justified, and this brings us to the second point, because it is there to induce compliance in the non-compliant state with the breach of the international legal obligation that has preceded the countermeasure. And this, in fact, is stipulated in Article 49(1) of the RCVA. In a way, countermeasures are the legal equivalent or the international law equivalent of sanctions, which is, of course, a more political term that we use in our everyday language. Now, as legal concepts, as a legal principle, countermeasures are therefore also governed by international law, and this is in fact what the other articles in this chapter of the RCVA do. Article 51, for example, establishes that a countermeasure must be proportionate to the injury suffered, which, for example, could involve therefore the non-performance of the same obligation that has been breached, but it doesn't have to be that. You can actually, as a state that has been injured, also refrain from performing other obligations insofar as they induce compliance in the violating state and insofar as they are generally proportionate to the injury suffered. Article 52 establishes a requirement for the injured state to notify the injuring state of its decision to take countermeasures and also to offer negotiations. Now, if the injuring state decides to get back into compliance with its international legal obligations, then countermeasures cease to be a valid option. Of course, the whole idea is to induce compliance, and if there is compliance, a countermeasure is not a valid way forward. There are, however, a number of obligations that are not affected by countermeasures, meaning that they cannot actually be breached in the name of enacting a countermeasure. These include, as outlined in Article 50 of the RCVA, the prohibition of the use of force under the UN Charter, human rights obligations, the prohibition of reprisals under the law of armed conflict, international humanitarian law, and of course use Kogan's norms, peremptory norms, from which there are never any exceptions or derogations. Moving on to the second consequence of international responsibility for states, we generally distinguish between three types of reparations that can and should be afforded under international law. These are restitution, compensation, and satisfaction. And in fact, there's somewhat of a sequential order here in the sense that the first one, restitution, should be provided, and only if it cannot be provided or only in addition to restitution do the other forms of reparation come into play. Article 35 of the RCVA establishes the requirement to provide restitution, which is the establishment of the status quo ante, the situation as it existed before there was a breach of international law. And this has to be provided unless, of course, as the article points out, it is not materially impossible or really completely undue in burden to the injuring state. The next provision, Article 36, deals with compensation, and this really is financial compensation insofar as damages cannot be made good by restitution. As Klabbers points out, we shouldn't consider these to be punitive damages, but, and this is also laid down in Article 38, these do include any interest that might have accrued due to the financial burden that the injured state has incurred. And finally, Article 37 establishes the requirement to provide satisfaction, especially if the two other modes of reparations cannot be provided. Now, satisfaction has a very specific meaning in international law, which is laid down in the second paragraph of this article, namely to acknowledge the breach, to officially express regret or to offer a formal apology. Of course, we can imagine this being particularly important when it comes to moral damages. One example in the international sphere being the 1999 bombing of the Chinese embassy in Belgrade during NATO's military campaign against Yugoslavia. And here, US President Bill Clinton decided to officially apologize to the Chinese government for this mistaken airstrike. This concludes this second video. In the third clip, I will address the role of non-state actors, starting with the question of indirect responsibility of states for their conduct.